Today we're going to be finishing up our talk on contract law, although we could go on for days and days. We're going to be finishing up the portion that relates to formation and then performance. So you can think of contracts in many different categories, but one of the two categories to think about is actually the formation part. So do we have a deal? Do we have an offer, acceptance, consideration? Do we have correct capacity for the parties to enter into the contract? Is it a legal contract? And if all those things are true, then we can go on to the next step in our analysis and start talking about performance of the contract. But if we don't have a properly constructed contract, if there's offer and acceptance but no consideration, then there's nothing to talk about relative to performance because we don't even have a deal. We might not even have a meeting of the minds. So I want to step back a little bit and cover some of the things that we didn't mention last week when we were talking about contract formation. Now, we were talking about offer and acceptance, and to remind you, the offeror, the person that's making the offer, is in charge of that offer. They're the master of the offer. And it's up to the offeree to either counteroffer with a rejection of the offer and a proposal for the new offer, or to go along with that offer as expressed. So let's assume for a moment that in this particular contract we're dealing with, I'm telling somebody that if they want to accept my offer, they have to mail me their acceptance in writing. And I'm asking them to place that in the mail, and I want that done by March 20th. All right, so if today's March 18th, they have until March 20th to accept my offer in writing. Now, how do they do that? Do they have to come to my office? Do they send me an email? Do they send me a text? Well, as the master of the offer, as the offeror, I will specify exactly how you can respond affirmatively as an acceptance. So if I say, I want you to mail me, Michael, I want you to mail me a response to my offer for my new Ferrari, and I'm going to sell it to you for $150,000, the moment he places his written acceptance in the mailbox, that's where we have the mailbox rule, that acceptance becomes effective. So if Michael waits till the 21st, maybe he wasn't really that serious about accepting the offer, maybe he wanted to think about it or linger on it, then if he responds in writing by placing his acceptance in the mail on March 21st, there's no deal, right? Because I said he has to accept my offer by March the 20th in writing. Well, he did the written part correctly, but he didn't put it in the mail correctly because it wasn't the correct date. Yes, Scott in the back.
So there's absolutely no deal, or is it up to you to decide whether to accept or decline?
So technically, at common law, there's no deal. So if there was some litigation over the issue, I would say, hey, sorry, he didn't accept on time. I was very clear. But as the master of the offer, I can still accept it if I want to. That's up to me. But what if I got many, many offers and everybody else complied and Michael didn't send it in on time? Then he's out of it, right? Yeah. Now, what if he called me up and said, hey, Mr. Silman, I really want that Ferrari. I'm not going to be able to get to a mailbox to the 21st. And I'm willing to pay you $5,000 extra. So now that's a counteroffer, right? Because any response to any of the terms in my offer that suggests a rejection of the principal offer, even in terms of how to accept that offer, becomes a revocation first and a proposal for a new offer. So I can say, sure, Michael, if you send me an extra $5,000, I will leave that offer open until the 21st. Now, what is the problem with my response? You'll see in a moment that under the statute of frauds, my response to Michael in terms of trying to keep that deal open longer was oral, correct? But we'll see in a moment that contracts for goods that are worth more than $500 must be in writing. So if the underlying contract must be in writing, right, that first deal must have been consummated by a written acceptance, then my oral attempt to renew the offer in a different fashion becomes volative and in violation of the statute of frauds, which we'll talk about in a moment. But right now, I just want everybody to understand the mailbox rule. So many people think that if I tell Michael he can respond to my offer by March the 20th, that I have to receive the offer. But as long as he puts it in the mail, or the mailbox rule is complied with, then we have a good deal. Now, if I would have changed the offer and said, Michael, I need to receive your offer in writing by the 20th, and today is March 18th, that might be difficult to accomplish. He might ask a question and say, well, can I text you my acceptance? Or can I email it? Now, his requests are in the form of a question, but if he's serious still about purchasing the Ferrari, and he just has some problems about how to respond to his acceptance part of it, that might just be questions for clarification. Now, I'm not sure if that's a counteroffer or question, so I'm going to ask him, so are you just asking questions? Are you really offering some new terms here, or are you just asking questions about the deal? And once I clarify, no, I'm serious. I really want to buy the car. I just can't get to a mail by time. And that's why I want to send you a text. And if I say, okay, it has to be in writing, of course, because the underlying deal has to be in writing. Then, if my extension of that offer is valid, it has to be in writing as well. But don't get hung up on that too much right now, because we haven't even talked about the statute of frauds yet. That's what we're going to talk about next. But any questions right now about the mailbox rule, how you can accelerate or comply with your acceptance even before the deadline is called for or on time by simply placing your written acceptance in the mail. Any questions about that? Okay, cool. Now we're going to go on to the statute of frauds. And so you know where we are in the contract arena. We're still in the formation stage, all right? Because if a contract doesn't comply with the statute of frauds, and it needs to, we're not going to go beyond that. We're not going to performance. We're still going to be stuck in the formation stage because we have no deal. So let's take a little bit of time and flesh out the statute of frauds a little bit. So, as I indicated last week, certain contracts must be in writing to be valid. At common law, there is something called the statute of frauds. Now, why do you think back hundreds, if not thousands of years ago, courts mandated that certain contracts be in writing? Not all contracts, just certain contracts. Why would the courts issue that edict and say, look, if a particular contract, let's say a land sale contract, is at issue, that has to be in writing to be valid? Why make certain contracts have to be in writing and others could be okay to be oral?
Maybe some things are way too serious to be... somebody can easily change the terms orally, so for it to be sure, it has to be written down and maybe like signed or something.
It's Edgar, right?
Yeah.
Absolutely correct. There's some contracts that are so important or serious, as Edgar indicated, that they are more subject to fraud, right? If I'm trying to buy Edgar's house and I'm trying to prove that I purchased the house, right, and the house is worth $1 million, there's a huge opportunity for either me or Edgar to be stretching the truth a little bit so I can end up with his house, or he can keep the house. And we'll talk about equity in a little bit, and something called specific performance, where if we have a good deal, I can actually go to court and enforce my contract with Edgar for him to transfer legal tender or ownership to me by virtue of a quitclaim deed or a deed. We'll talk about that in a moment. Don't worry about it. But Edgar's absolutely correct. The point is that some courts understood very early on that the more serious the contract becomes, the more higher the likelihood for fraud. And that's why we call it the statute of frauds, right? SOF means statute of frauds. So what I'd like to do now is enumerate for you some contracts that must be in writing. And then we're going to drill down. We're going to talk about the rules first, and then we're going to get even deeper into our analysis. So rule number 1 under the statute of frauds, transactions relating to real estate must be in writing. Now, I didn't say sales of real estate. I didn't just say buying or selling property, real property. I say transactions. So that could also be a lease. That could be something here in California. If I'm renting an apartment from Albert, that lease has to be in writing to be valid, right? And for Albert to protect his interests as a landlord, and me to protect my interest of right to possess, I don't have the right to own that apartment. Harking back when we talked about trespass to real property, only the landowner can sue for trespass to property. Those are his rights. As a tenant, I have certain rights, and that one of those rights is the right to possess the property once I pay the rent on time, and also the right of what we call quiet enjoyment. So because those rights are so serious, as Edgar indicated earlier, we want to have a written contract. So not just for sales of property, but I want to be able to enjoy my property in a quiet and harmonious way, as long as I'm complying with the terms of the agreement, which means paying my rent on time, or not bringing a pet in to the apartment if the contract says there are no pets. So that's one type of deal that must be in writing to be valid. Question?
How about if there is no written contract between the tenant and the landlord? Can the tenant use like front receipts and stuff, like to show that they've been living there?
Okay, so good question. The question is, what if there's no written contract? Now let me speak to California law. I'm not an expert in landlord-tenant law, by the way, that's my disclaimer. But in California, you may be able to still have a tenancy without a written contract. And at the time that Albert wants to evict me, if we don't have a lease, he probably still has to give me 30 days notice to quit the tenancy. And if we've been acting like landlord-tenant, I've been sending him a rent check, and he's been accepting it, and he's been cashing the check, then he's probably accepting the fact that we have a landlord-tenant relationship, technically. But if he wants to get rid of me, even though there's no lease, there still might be a good deal, right? Because both parties have performed. So now we're outside of the formation stage. We're already into performance because I'm paying rent, he's accepting it. So for one of us to deny the existence of a landlord-tenant relationship would be spurious at best. However, some of the rights could start to dissipate. One of them might be that when he wants to give me a 3-day notice to quit, he may not be able to, because if there's no contract, he could probably only give me a 30-day notice to quit the premises. But more on landlord-tenant relationships later in another class. We'll be talking about that, because it does touch on business law, particularly if you're leasing property. You need to know what your rights are as the lessee and the lessor. So, just so we're clear, and we're still talking about the statute of frauds now, property, real property, if you have a contract relating to real property for lease or rent or purchase, must be in writing, okay? Must be in writing. Now, the exception, as was pointed out, is we've already acted as if there's a landlord-tenant relationship and that contract has been fully performed. We're outside of the contracting and formation stage. All right, next rule. Next rule under the statute of frauds says that if a contract can't possibly be performed within 1 year, it must be in writing. So, this is sort of a mind-boggling inquiry. And the question is not, what is a contract that may be very unlikely to perform? My question is, what kind of contract can't possibly be performed, or it's impossible to perform with